morning, everyone, and welcome to this webinar. I'm delighted to be presenting a webinar, Acting for Lenders, part of a series of 5 webinars exploring good habits in connection with residential conveyancing. Once again, this event is sponsored by Stewart Title, and I'm delighted to say that Stewart Title, who have on a regular basis supported the legal profession with regard to training, once again stepped up and provided the facility for these webinars. And today we're going to be looking at some good habits. We're going to be looking at what we ought to be doing in connection with acting on behalf of a lender in connection with a residential transaction. If there are questions that arise with regard to today's presentation, then you can contact me, and you can also contact Stewart Title. And if there are any title indemnity issues or you're requiring a policy, then of course Stewart Title can be contacted, and their contact details are shown in the slides that accompany today's presentation. There are also notes that I will be referring to as I progress. And as I say, if you'd like a copy of the recording, or copies of slides, or indeed anything else, then your first point of contact should be Stewart Title. If there are questions or issues with regard to content, if you require clarification or amplification, feel free to drop me a line at the email address, which is also shown in the slides. So, good habits acting for lenders. Well, let's start with some basic issues. It's important that you keep up to date with some basic issues, and I make no apology for the fact that there's a reminder or a series of reminders in connection with this slide. It is important that we understand that acting on behalf of an institutional lender and a lay client can generate its own issues and own problems. It's also important that we're aware of the risk and vulnerability of mortgage fraud. We also have to look at some issues relating to due diligence and title investigation from the perspective of acting on behalf of a lender. There's some case law that I want to look at. We're going to talk a little bit about defective title insurance, and there are lots of other issues arising. Then once again, I have to apologize in that there aren't just 10 good habits that we'll be examining today. There are a significantly greater number that we'll be exploring. Please, which should be acting for both parties. Remember that it is possible to act for 2 parties in a conveyancing transaction where one of those parties is an institutional lender. And of course, remember a point that I tend to bleat on about whenever I'm given the opportunity. If we're acting for a collective client, husband and wife buying a property, partners buying a property, and a lender, in essence, we have 3 clients. And of course, the moment that we have more than one client, there is always a risk and vulnerability with regard to a conflict of interest, which we'll talk about in a little more detail shortly. But at this point in time, I just want to highlight that the general position is that where we're acting for an institutional lender, where that institutional lender has agreed their report on title or form a certificate of title with the law society, then we can act on behalf of our lay client, the buyer, and of course the lender too. And the same principles would apply in connection with acting on behalf of a seller. We're entitled to act for the seller's lender, provided that we're on the lender's panel, and again, provided a conflict of interest doesn't arise. The reason why that we are able to act in connection with an institutional lender and a lay client is that there is an assumption that there's a substantially common interest existing in connection with the transaction. In other words, the lender requires a good and marketable title as security, and the buyer requires a good and marketable title in order to sleep comfortably in their bed at night, knowing that the property they've got is their property and it's not subject to any form of third-party right that could cause them problems in the future. So when we talk about a substantially common interest, we're talking about a consensus as to how the transaction is going to be achieved, and that the potential conflict of interest that arises with regard to lender, client, and our firm's relationship is peripheral to this common purpose. So, excuse me, when acting for both parties, it is important that we understand that where instructions diverge, so lender's instructions are quite clear that they are insisting on an absolute freehold title, and client having been told that part of the title is a possessory title, lay client is saying, I'm happy to proceed. we've got to understand and appreciate that in those circumstances where lender is saying, I can't lend, this isn't adequate security, and where client is saying, we've got to proceed with the purchase, there is a conflict of interest. And in those circumstances, unless that divergence can be addressed and dealt with so that we have once more a substantially common interest, the transaction can't proceed. In short, the good habit here is to make sure that we're aware of an actual conflict of interest, but alive to the fact that with an institutional lender, there is always a potential conflict of interest. And remember that we might have in a co-ownership purchase, a husband saying, I'm quite happy with the defect in title that you've identified. Lender saying, we're quite happy, but wife, spouse, partner saying, I'm not happy with it. In which case, again, we'd have a conflict of interest that would require addressing. Not just actual conflicts of interest, I think we need to be aware of, but the potential. And the good habit is to be aware of that potential throughout the transaction. I'm going to talk about mortgage fraud in a lot more detail later. I mentioned it briefly in the notes at this juncture, but I now want to focus in on the issue of document ownership. So whether we've got an electronic file or a paper file, it's important that we understand who owns what within that file. The days of us having a separate file for a lender, a separate sort of paper file, are long gone in my view. It may be that your case management system has some form of system or approach that means that the lender's documentation is kept separate electronically. But it is important to understand that as far as ownership of documentation is concerned, the documents are either going to be owned by lender or they're going to be owned by lay client, or there will be some that in essence belong to both. So in the notes, I refer to the fact that we've got guidance courtesy of the Law Society's practice note on the 8th of December 2011. So we can actually say that lender's documentation includes mortgage deed, not surprisingly, copy report on title or certificate of title, correspondence copy, correspondence between lender and conveyancer, or conveyancer and third party, where the communication is written or received by the conveyancer on behalf of the lender. So that's not too drastic, is it? Nothing too much to worry about with regard to that. Things like contract, TA forms, inquiries before contract, pre-contract searches, related correspondence and ancillary documentation generated by the conveyancer relating to adverse entries or replies to questions in TA forms, then these documents, in essence, belong to both the lay client buyer and the lender and should be made available to both. So, generally speaking, we can understand and appreciate the division between the two. Often the division and the argument is an academic one because the borrower will have consented in the mortgage application form by way of waiver to facilitate the release of documentation on the file to a lender, sort of waiving the right to legal professional privilege. Good habit here is just to check what the mortgage offer requires of the borrower with regard to the file, so that we're clear as to what the position is. And also important in my view is to explain to the client the significance of that waiver. I'd rather do that at the start of the transaction, a good habit, than have to deal with it or confront it when there's a problem. So client suspected of mortgage fraud and lender saying, send us the file. Lay client saying, no, don't, you're breaching confidentiality if you do. And lender saying, mortgage offer or waiver contained therein that allows or compels you to disclose the file, notwithstanding client bleating. That's a harder conversation to have with the client if you haven't originally explained to the client what they've done with regard to that waiver. We're back to that old thorny issue, aren't we, of informed consent, making sure that our client is aware of what they're doing or what they have done and the significance of it. I mentioned in the notes a case of Mortgage Express against Sawali, which is an old case, 2010 case, which sort of highlights the points with regard to waiver or surrender by agreement or disclosure courtesy of a waiver provision in a mortgage offer. It is important to remember client confidentiality. It's a good habit to make sure that where clients have waived the right to confidentiality or privilege with regard to documentation, the client understands the significance of what they have done. We've already addressed the concept of substantially common interest, the acquisition of a good and marketable title on behalf of both parties. Lay client interested in ensuring that they have a secure home, and lender concerned about having adequate security in connection with the loan that they've provided for the acquisition of that home. Again, in the notes, I labour the point about co-owners and the fact that there could be 3 people in this transaction that we need to think about, or more accurately, 3 entities: institutional lender and Mr. and Mrs. Smith, our client buyers. It is important that we explain to clients the position with regard to a conflict of interest. And again, we are aware of client vulnerability relating to it. So we have to be sure that we're able to act. We have to be alive to the potential for conflicts of interest arising throughout the transaction, just not at the start. And remember, where we're acting for both parties, there's a degree of comfort if we're acting for an institutional lender. There is an obvious conflict of interest where a lender is not an institutional lender, or where a certificate of title or report on title is required in a form that hasn't been agreed or approved by the Law Society. We might be asked to do things with regard to that certificate or report that is in a position where there is a conflict of interest. We could have a conflict of interest where our lay client, the borrower's circumstances change, and that would impact on their ability to meet mortgage liability, or where there's evidence that the lender's security is not good and marketable and not sufficient for the loan advanced. There's a whole raft of circumstances where conflicts of interest can arise, and therefore it's dangerous for me to sit down with you and tell you these are the things you've got to look out for. What I've got to say to you is, as I mentioned to you already, that we have to be careful to make sure that we are constantly aware of the potential or actual conflict of interest arising. So, okay, Ian, you might be asking yourself, what do we do if we think, hang on a minute, there is a conflict of interest or a potential conflict of interest? Before you do anything, talk to a colleague. If you have a compliance team, talk to them and talk through what your view is. Where there is an actual conflict of interest, then we can't act for either of the parties, nor are we entitled to disclose to those parties what the conflict of interest is. If we are extracting ourselves from a retainer due to a conflict, then we've got to notify a lender that there's a conflict and return our instructions. But because of lay client confidentiality, we can't tell the lender what the problem is. As far as our lay client is concerned, if the conflict of interest arises due to what the lay client has told us or not told us, then we could explain the position. Can we act where one of the parties says, well, okay, I realize you can't act for both, but you can act for them, and I'll give you permission to do so? Answer yes. But again, be careful, because again, I lurch back to that point about informed consent. Does the client understand what they're doing in authorizing you to continue to act in those circumstances? So the good habit here is always to be aware of the risk, beware of vulnerability, and understand and appreciate your duties and responsibilities where a conflict of interest arises. All communications on a conveyancing file are confidential unless they're waived by client. So if a client emails you, if I'm your client and I email you about a problem or a delay in a transaction, then you can't just ping that email and forward it across to the other side without my permission. So it might be necessary, if you're going to be ultra cautious at the start of your retainer, to ask for permission to disclose issues that you think are relevant in communications received by your client to the other side in the transaction, explaining perhaps that to do so would ensure that you are being compliant with the conveyancing protocol. So the first point is obtaining permission to disclose. Where the client's permission is refused in the context of a notification to a lender, then again, conflict of interest, you would have to cease to act, telling the lender that you can't act, returning the instructions, but not explaining why. So a good habit here is to be constantly aware of client confidentiality. Let me scare you for a minute or two. If you're sitting on a train and you take a mobile telephone call from me as a client, and that call is on loudspeaker, that is breaching my confidentiality. That is potentially disclosing a conversation that would be privileged to whoever's sitting on the train or whoever can hear you. That's why some firms don't like fee earners taking calls on mobile telephones, particularly mobile telephone calls outside of the office. There are two issues. One, breach of client confidentiality, and two, of course, the fact that we may not properly be able to record the conversation to make a note of what is said, or there may be issues with regard to transmissibility of what's being said, and therefore missing bits of an important conversation. We have to be aware of all of those things. When I talk about client confidentiality, I always remember sitting on a train going from Leeds to Manchester and sitting opposite two lawyers who were senior partner and managing partner, I think, in a firm. I don't know whether the firm was based in Manchester or Leeds, but they were completing in front of me their proposal to a new professional indemnity insurer. And I always remember sitting there attempting to mind my own business, but overhearing whether or not they should in fact disclose a potential claim or not. And that's just taking the issue of confidentiality to the most extreme and ridiculous extent. Just I couldn't believe what I was hearing. Again, we've got to be careful to make sure that we understand and appreciate confidentiality, and in particular where we're disclosing information about lay client to lender, we've got to be very cautious about what we say and what we do. Again, permission is the obvious thing, and again, making sure the client understands what that permission actually means. I remember when I first started talking to practitioners about mortgage fraud and property fraud, and the statistic at the time was about 4% of the English property market was tainted with fraud, the vast majority of which was mortgage fraud. And there's nothing to suggest that the amount of mortgage fraud has gone down. In fact, given the amount of transactions that have been undertaken and how busy everyone is, statistically, the obvious point should be that mortgage fraud has or is on the increase. Cases, as I mentioned, such as Dreamvar and Currency, highlight the danger of seller identity fraud, but perhaps don't necessarily highlight the fact that the solicitors involved in both Currency and Dreamvar being potentially liable for either lay client loss or lender's loss, where seller is a fraudster, purchase price is wrongly remitted to someone who doesn't own title. So of course, in those circumstances, if a lender takes a hit, then the buyer's conveyancer and potentially the seller's conveyancer are going to be liable for loss. Now, during the course of the webinars that I've done for Stewart Title, we've examined the issue of fraud generally, property fraud generally, and mortgage fraud in particular. And it is important to understand that there are some products that Stewart Title can make available to your clients and indeed to your firm that will afford protection with regard to loss that a lender sustains. So there is a seller's identity policy that can be obtained. Where there are issues with regard to exposure or vulnerability relating to title, as we'll see a little later, and the lender is basically saying, well, you're our conveyancer, we're not saying whether we're happy with the title or not, it's down to you. In essence, they're relying on your professional indemnity policy, and where the lay client takes out an indemnity policy, or an indemnity policy is taken out on behalf of the lender, not only is the client being afforded protection, but you are being afforded protection as well. So verification of client identity, seller identity, important. Again, most people are aware of this fact. A buyer should not be asking the seller's conveyancer to warrant as to the identity of the seller client and to confirm that the seller client is one and the same as the owner of the title. Because a seller's conveyancer shouldn't answer that question. And the buyer's conveyancer generates liability and potential liability because they've highlighted seller identity as an issue, as a live issue in the transaction, but they haven't had the sort of response that affords the client protection. That's why I'm amazed that most conveyancers don't go running to Stewart Title when they're acting for a buyer to take out the seller identity policy, because if it's an issue, if it's a concern for the buyer client, if the buyer's conveyancer hasn't had a satisfactory response from the seller's conveyancer as to the risk or issue, then the risk or issue is highlighted, but there isn't any form of protection for the buyer client or indeed the lender. So do watch that. Watch out for seller identity fraud. Make sure, as I've stated, that we don't just think about fraud at the start of the transaction. Constantly throughout any conveyancing transaction, be aware of the potential for fraud. You might have information that reveals that the buyer couldn't possibly afford the mortgage payments that they're about to commit to. There might be indications from the buyer client that other people are going to be residing in the property other than the buyer themselves. The buyer may not have disclosed to the lender that's providing the mortgage that the buyer is in fact going to let this property out and has obtained a residential mortgage on the basis that the repayments and the interest rate will be significantly cheaper than a proper buy-to-let mortgage. These sorts of things we need to be aware of throughout. Where a lender sustains loss, and again, we're looking at the moment, we've got a rising market. Times are good, property prices are increasing 10, 20% a year, etc. But the moment the market turns and lenders start repossessing and taking a hit with regard to the amount that the property is sold for, and thus the amount that's released to the lender to redeem the mortgage, the lenders will start once more looking at conveyancers to recover that loss. So in those circumstances, we have to be very, very cautious about ensuring that we are checking information that our client is producing and being aware of anything that could be of use or significance to our lender client. Again, taking on board, however, all the points that I made about confidentiality. I mentioned in the notes, there's a load of case law on situations where lenders are pursuing claims against conveyancers. And I mentioned Davison Solicitors against Nationwide Building Society, a 2012 case, where the solicitors acting on behalf of the lender attempted to rely on Section 61 of the Trustee Act 1925, that basically permits a lawyer to escape liability in connection with a lender's claim where they have acted with reasonable skill and care. So the important point here is that Section 61 provides a defence if what you've done is reasonable. Now remember, that concept of reasonableness is significantly short of perfection. And also remember that the Solicitor's Conveyancing Handbook, edited by Silverman, written or contributed by my dear friend Russell Hewitson, sets out what is good practice in connection with residential conveyancing, but importantly, whilst in the majority of cases what the handbook says will be regarded as reasonable practice, generating the potential for a defence, that isn't an absolute position. A court will look at all the circumstances to determine whether what you did was reasonable or not in order to generate a defence under Section 61. So in Davison, you had a mortgage fraud and you had a lender sustaining loss. The important point with regard to this case was that the court's attitude on appeal was that Section 61 should provide a defence. And therefore, it is important to understand that when you're dealing with a lender and there is a suspicion of fraud, you are required or expected to behave reasonably. And when we talk about reasonableness, my first point of call would be the conveyancing handbook. But I should also take a step back and think about, well, how is this going to look if I find myself before a county court or a high court judge in connection with a claim being brought against me by the lender, or a situation where I'm submitting a report to my professional indemnity insurer with regard to the claim. As I mentioned in the notes, it is important to understand and appreciate that the courts will look at circumstances in the round and determine liability on the basis of what a reasonable conveyancer would do. But a reasonable conveyancer with regard to mortgage fraud would be alive to it throughout the transaction, would be checking and cross-checking data and information, and would be conscious of anything that would be suspicious activity. And again, it's important that that can occur at any point during the life of the transaction. And if we go back to Purensing and we go back to Dreamvar, remember what we've said, that the important point is that there could be a multitude of little things that altogether would enable a reasonable conveyancer to suspect fraud. Whereas in isolation, those small things would not be indicative of fraud in any way, shape or form. So it's not the obvious, it's not the sort of big thing, don't tell the lender, but I lied on my mortgage application about my income, or don't tell the lender, but in taking into account my income, they've taken into account a bonus that I received last year that I'm never ever going to get again. It's not that one, it's the sort of little drip, drip, drip of information, misinformation that perhaps is a significant issue when you look at it in the round. We've talked about identity. As far as the mortgage application is concerned, we're unlikely to see it. But if there is information that is disclosed to us by the seller that may be relevant to the insurer and may be an indicator of fraud as against the lender, what I would be doing is questioning my buyer client. And where the buyer client is not being honest or has told us something that would constitute mortgage fraud, then in those circumstances, we would have to decline to act and notify the lender that we can't act without telling them why. Again, where we are party to fraud or aware of fraud, then there is a danger that we are committing a criminal offence. And of course, that is going to be bad news all round. And therefore, we don't want to get into a predicament where allegations can be made against us. We also need to be aware of what the title reveals. So again, here so far, I've been talking about the borrower, but we also need to be alive to any issues that potentially could indicate fraud relating to the title. So again, here I'm touching on seller identity fraud, amongst other things. So watching out for suspicious activity throughout the life of the transaction is the important point to make. Undue influence is a key issue with regard to conveyancing generally and with regard to acting for a lender in particular. So we've always got to ask ourselves for our own benefit, is this client acting on their own free will? Is there any form of undue pressure or improper pressure being exerted on our client from a third party? Now that could be mortgage broker. It could be a situation where we have, say, a friend or family, son or daughter of the client, exerting pressure on the client. It could be a dominant cohabitee or co-owner inserting or exerting undue influence on their colleague, partner, or spouse. We have to be aware of that and alive to it. There could be special relationships that create a presumption of undue influence. And we have to be careful that when acting for a lender, we are not a conduit with regard to lender being aware of that undue influence. Very important point. Have a look at the case of Royal Bank of Scotland against Ettridge. Most of you will be familiar with it. Some of you that are relatively new to conveyancing may not be. Remember the guidelines that were provided in Ettridge and ensure that the lender's instructions that you receive relating to issues associated with undue influence are adhered to. Good habits are to obtain instructions from the client independently of anybody else. So if you've got instructions from me to act in connection with a purchase that my father is going to proceed with, then you need to sit down with father to make sure he has the appropriate capacity to give you instructions and that his instructions are satisfactory and are his instructions, not mine. Watch out for collective clients. Again, it's something I tend to bleat about when I talk to residential conveyancers, but I do so for a reason. Two tricks that you see quite commonly. One party saying to you, my partner works, very busy, doesn't answer telephone calls, doesn't respond to emails, therefore you're far better off communicating with me and I will transmit what needs to be transmitted to my partner. The what needs to be transmitted bit generates alarm bells, doesn't it? Because how do you know that the important point that you're transmitting to the client that is happy to receive communication is being transmitted to the party that I'll call the silent client? Two golden rules here and two good habits. One, if communicating party says, this is what I want you to do, and this is what he or she wants you to do, then we need to be speaking to the silent client that's giving us these instructions via the third party. To do that, I'd want a landline at work. I'd want to ring them and I'd want to say, I've just been speaking to your partner, your spouse, etc. This is what I've been told. Are you happy? And the other thing I would say, the other thing that I would do is during the life of the transaction, make sure that the silent party is made aware of what's going on and is authorizing me to exchange, is happy to complete. Because again, on a number of occasions, I've seen fraud perpetrated where the party that's communicating with you is in essence undertaking a deception or a fraud against the party that isn't communicating with you, particularly on sales. But it can happen on a purchase as well. You know, a mortgage fraud being committed. The silent spouse earning good income, being a good credit risk, and the party that actually is buying the property with the actual spouse, bad credit risk or problems or history with regard to criminal activity. So undue influence is important. Again, it's not just elderly clients. It can be young clients. It can be experienced clients. It can be clients that you've acted for in the past, and therefore you think you're comfortable with. And this is a good point to make, really, at this juncture. Do be careful that, you know, the old proverb, familiarity breeding contempt, is true. You know, I'm dealing with these clients. Last time I dealt with them, Mrs. Smith or Mr. Jones didn't communicate with me. So therefore, I'm just going to adopt the same strategy as I did on the last occasion. Well, you just don't know whether there's been a change of circumstances, and therefore it's important to check. With regard to undue influence, as I mentioned in the notes, the issue that we've got to watch out for is the fact that if we're acting for a lender, if we're aware of undue influence, then our knowledge can be transmitted to the lender. That can mean the lender is bound by third-party rights or bound by undue influence, meaning that they're not able to repossess the property. The next thing that I want to talk about is issues associated with title. The first point I make on slide here is the obvious one. If we're acting for a lender, we need to establish that there is a good and marketable title to the property. Where there are gaps in the title, a lender is quite happy for us to take out a defective title insurance policy, subject to the points that I'm going to make a little later. But it's important that we understand a good title and a marketable title are not the same thing, and that a marketable title is better than a goods title. A good and marketable title being a title that a reasonable conveyancer would be willing to accept upon performance of due diligence with regard to the conveyancing process. When we talk about a marketable title, the purchase price has to be taken into account and considered on the basis that the property would be marketable at that price, given the quality of title that the due diligence process has identified. If we're acting for a lender, we've got to make sure that we are registering a first legal charge. That is part of the report on title undertakings that are provided by us to the lender. We are undertaking that the title to this property is good and marketable, and that the lender will be registered with a first legal charge upon completion. Which leads me to an anomaly, namely the early completion procedure devised by the Land Registry. Interestingly, the Land Registry has been quite cute over the recent years, in attempting to extract themselves from potential liability with regard to indemnity claims. One of the things that they latched onto very quickly was the registration gap. The idea that we've got completion and then buyer's registration of title, or more accurately, registration of disposition after completion, but a gap ensuing, where in essence a buyer has an equitable interest in the property, but doesn't acquire the legal estate until registration takes place. The idea of the early completion procedure is a sort of hybrid process, whereby on completion, the buyer becomes the registered proprietor. The buyer's charge becomes a first charge on the title. The seller's charge remains on the title as a second charge pending redemption. Now that sounds fine. It sounds as if we're really speeding up the conveyancing process, and from a buyer's perspective, it's good news in that automatically at completion, the buyer is registered as proprietor. The buyer's charge is registered as a first charge in the charges register. The problem is that the fact that the seller's charge until redemption remains a second charge on the title. And the problem that professional indemnity insurers have identified is what happens if that charge is forgotten about or that charge can't be redeemed. You have a buyer who has a charge on the title that's nothing to do with them, and that theoretically the proprietor of that charge could repossess the property as against the buyer. So watch out for any transaction where the transaction involves the early completion procedure. That's bad news. The bit of good news for you is the early completion procedure only applies where there isn't a restriction on the title imposed by the seller's lender. Where that is the case, the early completion procedure cannot be adopted. And the other thing to watch out for when acting on behalf of a lender, just as you would when acting on behalf of a buyer, is to make sure that if there are restrictions on a registered title, those restrictions can be complied with. Remember, a restriction is designed to control or manage the registration of a disposition and will involve a requirement for a consent or certificate in all circumstances. Well, if you're acting for a buyer and a lender, it is important to ensure that that restriction can be complied with in order for you to comply with your undertaking to the lender to facilitate the lender obtaining a first legal charge over the title. If there is a restriction on the title that can't be complied with, then your lender client cannot be registered with a first legal charge on the title. That can only take place when the restriction is being complied with or where the restriction is being disapplied, cancelled or modified. With regard to disapplication, modification and cancellation, there is a likelihood that there will be a delay whilst that process is being undertaken. So watch, good habit when you're dealing with acting for a lender in connection with a registered purchase is to make sure if there are restrictions on the title, the restriction can be complied with, or alternatively, the seller has before exchange or certainly before completion applied to the land registry to disapply the restriction or to modify or cancel it. In the notes, I mention at length some other problems with regard to title, and don't have the time, unfortunately, to go and talk to you about them at length, but I'll just mention them briefly if I can. Some of these issues you will have covered and been aware of, some of them you won't. And the first thing I mention is watch out for estate rent charges. Given the government's dissatisfaction with the concept of leasehold houses, you are seeing developers now developing a freehold development where there are common parts, etc., and dealing with management and costs relating to repair and maintenance of common parts via estate rent charges. Lenders don't like estate rent charges because where an estate rent charge is unpaid, one of the remedies in connection with the estate rent charge owner is to take a charge over the property. And that charge would prevail over the lender's security. And the only way that charge can be removed is by the owner of the property paying off the estate rent charge liability and the costs that have been incurred in connection with the creation of the lease to protect the estate rent charges owner's security. So where you're looking at estate rent charges, you want, first of all, some form of cap or ceiling with regard to how much the estate rent charge can be. Secondly, you want some form of mechanism that enables a lender to be aware that an estate rent charge is outstanding and that the estate rent charge owner is attempting to enforce by the creation of lease. And then you also need provision that facilitates the fact that the lender can intervene in connection with the intended process to be undertaken by the estate rent charge owner to prevent the lease from being created. So watch out for estate rent charges. In talking about estate rent charges, it's important, I think, to explain to practitioners that when concerned about the lender's vulnerability, Stewart Title are able to come to the rescue because I think, and if I can introduce Robert Kelly at this point of my presentation, I think, Robert, there is a product specifically relating to estate rent charge risk from the perspective of lender and lay client. Could you explain a little bit about that for us, if you don't mind?
Yes, Ian, we do. Following all the discussion about the Section 121 problems with estate rent charges, and particularly the risk for lenders that they can effectively lose their security within 40 days, we have produced an estate rent charges policy, which does cover the lender only, but it does mean that the lender is put in a position that if they lose their security, then they can claim on the policy, and we will try and resolve the situation for them, or ultimately pay out what's existing under the loan. It is useful for them, and as you'll know, a number of lenders do accept insurance where there's an estate rent charge problem, and as you said earlier, you can find that in the finance handbook relevant section as to the attitude of any lender to it.
Thanks for that, Robert. So the interesting thing about that is, again, a point I alluded to earlier, the fact that, you know, that policy really protects the firm, doesn't it? It protects the conveyancer, you know.
Yeah, exactly. Yeah. It does mean that you are protecting the lender there. And as you said, it's another situation where the interest of the lender as your client is as important as the borrower. and this does give a cover there and would help protect your firm against a possible claim if there's a risk in the future, because that is the only recourse for the lender at the moment, is to go against a conveyancer.
Thanks for that, Robert. That's great. Thank you very much. Some lenders are not now lending where a registered freehold or leasehold purchase is composed of more than one registered title. So we're buying Blackacre. Blackacre is a large detached property composed of 3 separate registered titles. There are some lenders that will say we're not prepared to lend on 3 separate registered titles relating to that property. It is possible for the seller to voluntarily apply to the land registry to amalgamate the 3 titles into one. The land registry is moderately comfortable with that. Be aware, however, the land registry is not comfortable with titles being subdivided. And the reason for that is a fraud that used to be perpetrated a few years ago. But if there are numerous titles that are being acquired as part of the purchase of one property, check your instructions to make sure the lender is happy. If the lender is not happy, then be aware that it's possible for the titles to be amalgamated. Also, again, I mentioned another point here that is worth talking about. If you've got a possessory title, someone just asked me about this morning, a possessory title, and you have had a possessory title for a period in excess of 12 years, if your client is in occupation of that property, remember you can upgrade the title to an absolute title, and the seller should do that for you as part of the conveyancing process before you submit your report on title. With regard to leases, again, I mentioned a lot of potential problems with regard to leases and lenders. And in essence, you've got a webinar in its own right. You've probably got a 3-hour course, to be honest with you, to talk about this problem. But I highlight some common issues. Ground rent review provisions. Watch a situation where you have a ground rent review that enables the ground rent to increase dramatically, or where the ground rent doubles, or where the ground rent increase is linked to an indices, such as the rate of inflation, bank base rate, retail price index. The problem with all of these things is you could see a dramatic increase in ground rent at the point of review. Some lenders, when looking at leasehold security, will utilize the extent of the ground rent in determining value and loan to value. A lot of lenders will get particularly jumpy if there is ground rent review provision. That means that on review, the ground rent is unascertainable at the point of acquisition. So I'm buying a new leasehold flat today, 2021, ground rent review in 2031, and the ground rent review is to enable the ground rent to be increased to 2% of market value of that flat. As of 2021, I can't tell you what the market value of that flat will be. Therefore, I can't tell you what the ground rent will be when the ground rent is reviewed. Be careful with ground rent review provisions. Someone asked me yesterday, could you apply to first tier tribunal under section 37, was it 137? 37 of the Landlord and Tenant Act 1987 to vary the lease? And the answer to that question is, if you have a block of flats where all the flats in the block have the same provision, then under section 37 of the Landlord and Tenant Act 1987, you can ask the tribunal to vary the lease. You do that because section 37 allows a tribunal to vary a lease on the basis that the majority of interested parties require it to be varied. Section 35 of the 87 Act only allows a tribunal to vary a lease if the lease is defective. And the lease is not defective simply because there's ground rent review provision that means that the ground rent on review will be in excessive sum as far as the leaseholder is concerned. Watch out for vague or ambiguous provisions in leases and make sure that a lender is aware of what those vague or ambiguous provisions are. Term. Again, most lenders will say, provided the term is 25 years beyond the extent of the mortgage term, we're happy to lend. well, that's fine, but again, I would always warn a lender client where the term remaining is 80 years or less. On the basis, if it's necessary to repossess, there could be issues with regard to the amount that's required to extend the lease that could impact on lender's security or value of property, and therefore ability of lender to redeem. Also watch out for forfeiture clauses in residential leases. The big thing to look out for, and the good habit, is to check that forfeiture is not possible courtesy of leaseholder insolvency. Some residential leases now contain break clauses, particularly landlord break on the basis of inability to reinstate. Check lender's instructions. Some lenders will allow such a clause and will still regard the property as being adequate security, provided the landlord, the landowner, utilizes insurance money and site value and distributes equitably to leaseholders the insurance monies and site value monies that they receive. Thinking being that will be sufficient to enable the legal charge that the lender has imposed on the property to be redeemed. Remember that a lender is going to obtain a valuation with regard to target property. Remember also that our buyer client may well rely on that valuation, and it's important that we check it as well to see if there are any issues relevant to title that we need to know about. Also, particularly if a property is leasehold, it may be necessary to advise the valuer or to report to the valuer any issues with regard to the lease that you think would impact on valuation. And the same thing would apply with regard to service charge. In addition to that, remember what I have said to practitioners on a regular basis about the lay client understanding and appreciating the limitations relating to survey. And I again refer to the RICS Consumer Guide to Survey and Valuation, which should be provided to clients to explain to the clients the choices available to them and the limitations with regard to relying on a lender's valuation. As far as TA forms, searches, etc., again, adverse entries relating to any information that is revealed should be disclosed to a lender, and the lender asked whether or not they're prepared to lend, and whether or not, from a valuation perspective, there are issues with regard to security. Here I want to make a point. Often, as I've mentioned already, a lender, when you ask them, this is the issue, are you still happy to lend? They'll say, well, it's down to you. Where there's an issue with regard to the issue that you've identified affecting valuation, you should be saying to the lender, you should be taking this matter up with your valuer to determine whether or not the point that I've identified and drawn to your attention would impact on valuation. I've also given you some notes within the notes on cladding issues in connection with fire safety and use of EWS1 and the relationship between you and the lender with regard to fire safety issues. Remember, an EWS1 is not a fire certificate. It's not confirmation that the property is safe or otherwise. It is a form that is used to determine if there are fire safety issues that warrant further investigation. And again, if there is an issue with regard to fire safety, if there is an EWS1 that's been obtained or about to be obtained with regard to a building, your task is simply to transmit that to the lender's valuer, and your task is also to see where the EWS1 reveals fire risk, what steps are recommended. So there should be an additional report in addition to the EWS1 that should assist your client, the lay client, and the lender with regard to their decision whether or not to proceed. The report on title is normally, for an institutional lender, a standardized document confirming, one, that there aren't any problems with regard to the title, confirming that there's a good and marketable title, and confirming that the lender will be registered with the first legal charge on the title at completion or within priority period of land registry search. So it's important that we understand that we're giving undertakings to the lender. It's also important to understand that where we've got a lay client that's saying, I want to buy this property, I'm not bothered about the defects in title that you've identified, it's still necessary to report those defects in title to the lender and to get confirmation from the lender that they're happy to proceed. Remember that we should be relating the information that we have obtained with regard to due diligence to our lender's instructions. The idea here is that there is a good and marketable title and that we will be able to ensure that they're registered with the first legal charge on that title. Of course, there is a risk of conflict of interest. Of course, there is a requirement simply to complete the form that the lender has sent out to us. And in doing so, there may be issues or problems with regard to the title that the form does not permit us to transmit to the client. Lender, in those circumstances, you would email the lender and say, I've sent the report on title to you, but that report on title is subject to these points that require addressing or require your attention. Remember, if we have a non-standard form of certificate or report on title, we are probably dealing with someone other than an institutional lender, and there are issues about our ability to act in such circumstances in the first place. It is too late to address that or deal with that when we're about to submit the report on title to our non-institutional lender client. We should have thought about that at the start and probably declined instruction. It's important to understand that a report on title to a lender, which although may simply be a signature and a date on the bottom of an email or on the bottom of an electronic form, is significant and can ultimately create liability for us with regard to a lender who sustains loss as a consequence of our failure to comply with the standards expected of a reasonable conveyancer. The good habit always when completing a report on title is to do a review. Ask yourself, is this a good and marketable title? Have I disclosed any problems or issues to my lender client? And am I convinced and comfortable that I can register the charge as a first legal charge on this title after completion? Of course, it is important to understand that where there are defects in title, it is perfectly acceptable to take out title indemnity insurance or defective title insurance. But in doing so, we've got to be aware of the lender's requirements. And the lender's requirements require us to verify there's a good and marketable title. But that it is possible to undertake a defective title insurance policy that will plug the gap with regard to a defect in title, subject to certain obligations. And those obligations are that the lay client pays the premium. And those obligations also include that we ensure that our lay client has explained to them what a defective title insurance policy does and does not do. Therefore, it is important that the lay client understands the benefits of a defective title insurance policy, and those benefits are significant, and that they're going to allow this transaction to proceed and allow the lender to lend on what would otherwise be a title that would not be capable of being security, but that there are duties and responsibilities imposed on the lay client as a consequence. And I've referred there to Lender's Handbook Condition 9 in the notes, providing borrower with a copy of the policy and explanation why the policy was affected and that further policies may be required if additional lending is required. Explain to the borrower needs to comply with the conditions of the policy and that those conditions, those duties and obligations to the insurer will continue during the ownership of the property. They are not just relevant during the conveyancing process. So when we close our file, the client's obligations to the insurer continue indefinitely. We've got to approve the terms of the policy on behalf of the lender. We've got to check that the level of indemnity must fulfill the requirements of the lender, and you must disclose to the insurer relevant information which you've obtained. So all of those things need to be satisfied. Now, again, with regard to limits of indemnity, I'm delighted to say that Stewart Title have a great deal of flexibility with regard to indexation relating to some policies, and will give you guidance as to what a limit of or an appropriate limit of indemnity will be. I would always be saying to a residential conveyancing client that the level of indemnity is always an arbitrary sum. Therefore, the client may well be overinsured, may well be underinsured. We don't know until a claim is received. But the benefit of a title indemnity policy is that it gives you a shield or a sword with regard to fighting claims or defending claims, and also will give you an opportunity to recover loss that you sustain as a consequence of that claim. Important that the client understands what the extent of that loss may be. It may be diminution in value. As far as lender is concerned, the lender is simply looking at a defective title insurance policy or title indemnity policy to protect its security. So is it going to get the amount outstanding on its loan back in the event of a claim? And to that extent, the issues that are relevant for the lay client under condition 9 aren't quite as extensive as they would be, aren't quite as extensive for a lender. The lender is just simply saying, have I got an indemnity policy that's going to cover the amount of my loan or the amount of loan that's outstanding? Be careful with pre-existing policies. Make sure either you perform a due diligence exercise with regard to the insurer, or you get warranties from the seller with regard to what has been disclosed to the insurer and what the seller's awareness is. And the good habit here is to explain benefits and limitations of policies to the lay client, so the lay client ensures that the policy remains effective. That will be significant from a lending perspective. A lender may well, if the policy is not called upon or doesn't meet a claim, may well pursue a claim in negligence against you if you haven't told the client that's taken out the policy about their duties and obligations under that policy. In the notes, I've given you quite a lot of case law that touches on a number of issues. The first one, Edwards and Bank of Scotland, concerns a forged legal mortgage. And again, that highlights a number of points that I've made about, collective lay clients and about watching out for circumstances that would lead to a lender being liable or not being able to repossess or sustaining loss. And again, Hughes Holland and BPE Solicitors 2017 case, again, highlighting the fact that where we're acting on behalf of a lender, we've got to be careful about looking at the circumstances of the transaction and what the client is doing, and being aware of the risk of conflicts of interest arising. I've also mentioned Skipton Building Society against Clayton, a sort of sale and leaseback arrangement where the circumstances were such that the deal was a particularly bad deal for the lay client, and the lender becoming embroiled in a dispute relating to that. So where you're in a situation where a transaction is particularly onerous for the lay client, how does that impact on the lender client? And again, what should we be telling and what can we tell the lender client about the transaction? I've also given you Woolwich Building Society against Dickman, an older case 1996, that again highlights some problems relating to a situation where a property is acquired, but the property was always intended to be let, and the lender was not aware of that, but solicitors may have been aware of it. Again, just being careful about being able to disclose problems or issues relating to title to the lender client. So there's quite a bit of case law there for you to have a look at. To finish today, what I want to do is to finish how I started, and to thank Stewart Title once again for being the deliverer of training products to the legal profession, to allow me to spend a bit of my time explaining to conveyancers some good habits with regard to acting for lenders. With what I've said today, you will see there's lots of opportunity to take out defective title insurance policies to protect the lay client, to protect the lender, and of course to protect yourselves. And the beauty of Stewart Title is that they've got product that is available simply online, that you can obtain at any time, download sort of immediately. But they've also got a wealth of experience with regard to underwriters and a support team that can assist with regard to what do we do here? Do we take out a policy? We are going to take out a policy. What do we need to do? What does the insurer need to know? So you've got that facility, and you've got Robert Kelly and Stephen Smith, who are able to assist with regard to product awareness, training, etc., with regard to Stewart Title products. So thank you to Stewart Title. Thank you for watching. My name is Ian Quirrell from IQ Legal Training. All I can say is thank you very much indeed for attending and wishing you all a good day. Thank you.